Welcome back, dear students. Today we will understand the kinds of writs provided in our constitution. There are 5 kinds of writs which are available to a person under Article 32 for moving Supreme Court and under Article 226 for moving any of the High Court in our country. So first of all, we'll take up the writ jurisdiction of High Courts in India. Article 226 of Constitution of India provides that notwithstanding anything contained in Article 32, every High Court shall have power throughout the territorial limits in relation to which it exercises jurisdiction within which the cause of action wholly or partly arises, to issue to any person or authority or government within those territories directions, orders, including the writs in the nature of, there are 5 writs. The abbreviation is HMPQC. H stands for habeas corpus, M for mandamus, P for prohibition, Q for quo warranto, and C for certiorari, or any of them. So these are the 5 writs which are available, whether you move High Court or whether you move Supreme Court, as the case may be. But if you are moving your writ in the High Court, then these or any of these writs can be issued for dual purposes. The first purpose is for enforcement of fundamental rights conferred by Part 3rd of our Constitution. And then second, for any other purpose. Any other purpose means for enforcement of other legal rights which are not included in the category of fundamental rights. So all other constitutional rights and ordinary legal rights can be enforced by filing a writ in the High Court. So dear students, the jurisdiction of all the High Courts in India is not limited to the enforcement of fundamental rights only, but it extends to other legal rights also. So you can say that power of the High Courts are more extensive than that of Supreme Court, because Supreme Court will entertain your writ only and only when your fundamental right is violated. So 226 is the section which empowers the High Courts to issue any of these 5 writs. And Article 226 Clause 1 says that notwithstanding anything in Article 32 Clause 2, every High Court shall have power throughout the territories in relation to which it exercises jurisdiction to issue to any person or authority, including in appropriate cases any government, within whose territories the cause of action arose, to issue directions, orders, or writs, including the writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, or any of them. For what purpose? For the enforcement of any of the rights conferred by Part 3rd and for any other purpose. So High Courts have a wider jurisdiction. Then Clause 2 of 226 says that the power conferred by Clause 1 to issue directions, orders, or writs to any government, authority, or person may also be exercised by any High Court exercising jurisdiction in relation to the territories within which cause of action wholly or partly arises for the exercise of such power, notwithstanding that the seat of such government or authority or residence of such person is not within those territories. The meaning of Clause 2 is that if cause of action has arisen, suppose I am a resident of Noida in Uttar Pradesh, and my fundamental right has been violated in Noida. So I will have to file my writ in the Honorable High Court of Judicature at Allahabad. Because cause of action arose in state of UP, I cannot file my writ in the Delhi High Court because the cause of action arose at Noida. But if cause of action partly arose in Noida and partly in Delhi, then I have an option of moving my writ petition either in Delhi High Court or in Allahabad High Court, because the cause of action has arisen partly in both the states. So it is immaterial that where the respondent is residing. If I am filing my writ in Allahabad High Court and it is against the state of UP as well as against government of NCT of Delhi, then it is not necessary that the seat of the government or authority or resident of respondent is not situated in UP. It doesn't matter. If I am filing writ in Allahabad High Court, it's okay. Even if the government of NCT of Delhi is also involved, they have also violated my fundamental right. Then, dear students, if you have seen sometimes that a petitioner who files a petition in the High Court or Supreme Court generally craves for interim order in the shape of stay order. And then once he gets the stay order, he tries to keep the writ petition pending for a longer and longer period. He doesn't want that stay should be vacated. Now a provision has been added in Article 226 Clause 3 that the person against whom the stay order has been passed by way of injunction or interim order, now he is worried. And he is worried to the extent that he wants that stay order should be vacated. Now respondent has to move an application to the High Court for vacation of the order, because on the day one when the writ was filed, the respondent was not present before the court. Copies of the petition were not served to him. Copies of the document filed in support of the writ were also not shown to him, or copies were not given to him. And not only this, he had no opportunity of being heard on the day one, because on the day one only petitioner and petitioner's counsel is before the court. So now respondent is moving an application for vacation of the stay. And he has given the copy of this stay vacation application to other party also or his counsel. Then now it is the duty of the High Court to dispose of this application for vacation of stay within a period of 2 weeks. 2 weeks from the date on which it is received, or from the date on which the copy of such application is given to an opposite party. And if on the expiry of 2 weeks, suppose the High Court is closed because 2 weeks are ending on second Saturday or Sunday or any other holiday, then on the next reopening day, the High Court has to decide that application for vacation of the stay within a period of 2 weeks. And if it is not decided within a period of 2 weeks, then that ex parte injunction or ex parte stay order, which was granted to the petitioner on day one, or even later on in the absence of the respondent, that stay orders will stand vacated. This is a new substitution in the shape of Article 226 Clause 3. Then 226 Clause 4 says that powers conferred on a High Court by this article, that is 226, shall not be in derogation of the powers conferred on the Supreme Court by Clause 2 of Article 32. That means the jurisdiction of the High Courts as well as Supreme Court is concurrent. These powers are not in derogation of the powers of the Supreme Court. They have their independent powers. Then, dear students, there was an amendment in Article 226 and 32. Article 226 capital A and Article 32 capital A were added in our Constitution. And the idea was that constitutional validity of central laws will be considered by the Supreme Court and High Courts will not touch. the constitutional validity of central laws. Similarly, the Supreme Court shall see to the constitutional validity of central laws, and they will not look into the constitutional validity of state laws. So state laws will be respectively tested by respective high courts, and central legislations will be tested by the Supreme Court. This amendment was added in Article 226 and 32 by 42nd Constitutional Amendment Act with effect from 1st Feb 1977. But these two articles, 226 capital A and 32 capital A, were repealed by Constitution 43rd Amendment Act with effect from 13th April 1978. So now the current position is that High Court as well as Supreme Court both are authorized to see and check and test the constitutional validity of either the state law or the central law. We have a very important leading judgment on the power of the writ of the High Courts. That is L. Chandra Kumar versus Union of India, decided by the Supreme Court way back in 1997. Supreme Court in this case held that power of judiciary over legislative action vested in the High Courts under Article 226 is the basic feature of Constitution of India, and therefore it cannot be ousted or excluded even by way of constitutional amendment. Accordingly, Supreme Court declared Article 23 capital A and 223 capital B as unconstitutional because they excluded the jurisdiction of the High Court and gave this jurisdiction to tribunals. So this cannot be done. You cannot take away the power of judicial review, which is given to all the High Courts and Supreme Court by way of legislation. Parliament has no power to make such a law which takes away the power of judiciary, which is granted to the High Court under Article 226, because 226 itself is a basic feature of Constitution of India as held in L. Chandra Kumar versus Union of India. By this legislation, the power of the High Court was taken away and power was given to the tribunals. Tribunals were rather substituted for the High Court, in a sense you can say. In other words, the jurisdiction of the High Court under Article 226 of Constitution of India was minimized, was reduced. Hence, Article 323 capital A, Clause 2, Clause D, and 323 Clause B, Clause 3, Clause D were declared as unconstitutional since they excluded the jurisdiction of the High Court. This 226 Clause 3, I told you that application for vacation of stay order can be filed. This was substituted by 44th Constitutional Amendment Act, which says that if an injunction or stay order has been granted in a writ petition without furnishing copies of such petition and all documents in support of the plea to other party, and when such party is given an opportunity to be heard. So if the respondent moves an application for vacation of stay, then High Court has to decide that application for vacation of the stay within 2 weeks. And if it is not decided within 2 weeks, then stay order shall be vacated automatically. The stay order shall stand vacated automatically. This I just told you. Then, dear students, this is also important with reference to writ jurisdiction. the concept of locus standi as to who can apply for writs. If my fundamental right is violated, the normal rule is I will file my petition because I have a right to stand in the court. That is known as locus standi. But of late, you will see that Supreme Court and high courts have liberalized the concept of locus standi, and anybody else can file writ petition in the High Court or Supreme Court on behalf of another person also. So locus standi here means the right to bring an action to be heard in a court on a matter. Otherwise, court will rule that plaintiff lacks standing to bring suit and his suit will be dismissed without consideration of merits of the claim. You will have to show that you have a right to interfere, right to speak, right to stand in the court. So dear students, the traditional rule is that a person whose constitutional or legal right is infringed, he alone can apply for relief under Article 226. But as I told you, Supreme Court has now considered and considerably liberalized the rule of locus standi. Public spirited persons are now permitted to file writ petitions for the enforcement of constitutional and legal rights of any other person. If that person or class of persons is unable to invoke the jurisdiction of the high courts or Supreme Court on account of poverty or any social or economic disability, such actions are known as class action litigation or public interest litigation or representative litigation. Class action litigation means when one person is representing a class of litigants. Public interest litigation means where one litigant is representing the interest of general public. And similarly, the representative litigation means where one person is representing a group of persons. Suppose a village pradhan is filing writ petition on behalf of the whole village. That is known as representative litigation. And dear students, there is a new concept also when court exercises jurisdiction in PIL, public interest litigation, through letters or on the basis of newspaper reporting. That jurisdiction is known as epistolary jurisdiction of the court, which means acting on a letter written by or on behalf of the oppressed people. This strategy is adopted by the Supreme Court for facilitating access to justice to masses. Take the example of Baba Ramdev. The name of the case is regarding Ramlila Maidan incident versus Home Secretary. What happened in this case? That Baba Ramdev, along with his disciples, they were holding a camp, religious camp in Ramlila Maidan. And after spiritual preachings, after taking dinner, everybody slept in the tents in the Ramlila Maidan itself. But in the midnight, the administration decided to remove all the tents and disciples of Baba Ramdev from Ramlila Maidan. And this was done by the police. There was a lot of hue and cry at Ramlila Maidan when the police reached there and wanted to remove all the disciples, including Baba Ramdev himself. And so much so that Baba Ramdev had to escape from Ramlila Maidan after wearing the attire of a lady. He had to change his visibility and personality so that he may escape, and he escaped from the Ramlila Maidan. Next day morning, this news was published in all the leading papers of the country, and Supreme Court took cognizance of this case on the basis of newspaper reporting only. That is under epistolary jurisdiction. And Supreme Court said that how sleeping disciples, sleeping persons can be a threat to law and order. How sleeping persons can make unlawful assembly. Everybody has a right to sleep. A new fundamental right to sleep, was carved out in this Baba Ramdev's case. So Supreme Court exercised its epistolary jurisdiction and treated that newspaper clipping as a writ petition and passed the necessary orders. Then coming to parallel writ jurisdiction of the Supreme Court, my dear students, you know that fundamental rights are given by our Constitution, but if adequate remedy is not prescribed for their enforcement, they will become meaningless. Article 32 and 226 gives writ jurisdiction to Supreme Court and all the high courts of our country. Article 32 of the Constitution is the most important article. Why? This article describes the last of the 7 groups of fundamental rights. This right is remedial in nature and not substantive. Anyone can move directly to the Supreme Court under Article 32 for the enforcement of fundamental rights, not for other legal rights, only for enforcement of fundamental rights. And Article 32 Clause 1 says that right to move the Supreme Court by appropriate proceedings for the enforcement of rights granted by Part 3rd is guaranteed. Appropriate proceeding, what does it mean? Appropriate proceedings under Article 32 mean as defined in 32 Clause 2. That is, Supreme Court shall have powers to issue directions, orders, or writs, including the writs. Again, the number and name of the writs is same. That is HMPQC. Habeas corpus, mandamus, prohibition, quo warranto, and certiorari. So this is your fundamental right to constitutional remedies through Article 32. So heading of 32 says that these are the remedies for enforcement of rights conferred by this part. This part means Part 3rd, that is fundamental right. So 32 Clause 1 says that right to move the Supreme Court by appropriate proceedings for the enforcement of rights conferred by this part is guaranteed, and Supreme Court shall have power to issue directions, orders, or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. 32 article is a part of Part 3rd of the Constitution of India. So if any fundamental right is violated, you can approach straightway to the Supreme Court. Dear students, I have highlighted the words writ in the nature of. See, these are the 5 writs, but their scope is very large because of these words in the nature of. In the nature of habeas corpus, in the nature of mandamus, in the nature of prohibition, or in the nature of quo warranto or certiorari. So these words in the nature of enlarges the scope of the writ jurisdiction of the Supreme Court, as we discussed in case of High Court also. Then, dear students, the Parliament has a power to empower any other court to exercise within its local jurisdiction all or any of the powers exercisable by the Supreme Court under Article 32 Clause 2, meaning thereby that this writ jurisdiction of the Supreme Court can be delegated to other courts also. But after the commencement of Constitution of India till date, this power was never exercised by the Parliament, and none of the court other than Supreme Court is authorized and competent to issue any of these 5 writs under Article 32 Clause 2 for enforcement of fundamental rights. Dear students, I retired as District and Sessions Judge from UP Judicial Services, and our association had kept this demand before the High Court and Supreme Court several times that by virtue of Article 32, Clause 3, the district judges all over the country should be empowered with the writ jurisdiction. This was our regular demand, but this demand was never accepted by the government. And Clause 4 of 32 says that the right guaranteed by this article shall not be suspended. You cannot suspend the operation of Article 32 except as otherwise provided for by this Constitution. If proclamation of emergency is announced by the President of India, only then Article 32 can be suspended. Otherwise, this fundamental right cannot be suspended. And I told you regarding the addition and abolition of Article 32 capital A also. So, dear students, by now we can safely conclude that writ jurisdiction of issuing the writs of habeas corpus, mandamus, prohibition, quo warranto, and certiorari is a concurrent jurisdiction available to all the high courts and Supreme Court of India. Article 32, Supreme Court will exercise its powers only for enforcement of fundamental rights. And this jurisdiction conferred upon the Supreme Court and High Court is an integral part of the basic structure of Constitution of India. So once it is basic structure, you cannot amend 32 and 226. High courts will exercise their powers under Article 226 for enforcement of fundamental rights as well as for enforcement of other legal rights. So dear students, whose jurisdiction is wider? Is it Supreme Court or High Court? Natural answer is that High Court's jurisdiction is wider because they are looking after the enforcement of fundamental rights as well as other legal rights. And dear students, the nature of jurisdiction, if you see, under Article 32 and 26 is not appellate. But this jurisdiction is supervisory in nature. However, court can exercise all necessary appellate powers to do substantial justice, but basically they have supervisory powers, not appellate. Power of the Supreme Court under Article 136 of Constitution of India to entertain special leave petition is also purely supervisory, not appellate. We have discussed the concept of locus standi with reference to power of the High Court. Same applies to the power of the Supreme Court also. And the normal rule is that only a aggrieved person can file a writ. Exception is habeas corpus and PILs. Why habeas corpus? Suppose police has detained me at the police station and they are not releasing me since a week or so. I'm confined there. How I will file writ petition? So obviously my family members, my friend, my advocate, or any NGO or public spirited person should be allowed to file habeas corpus writ petition because I am detained at the police station. So habeas corpus is the exception to the rule of locus standi, which means that only a aggrieved person can file a writ. And second exception is public interest litigation, where a public spirited person is filing a writ on behalf of the general public, although he has no locus standi. His fundamental right is not violated. The fundamental right of some other people are violated, and he is filing writ petition on behalf of all those persons. So dear students, the emergence of this pro bono publico litigation. Pro bono publico means where public at large is involved in the case, but the petitioner is not. So emergence of pro bono publico litigation, that is a litigation at the instance of a public spirited person espousing the cause of others, is known as PIL or social action litigation or representative action. And this PIL can also be filed under Article 32 before the Supreme Court and under Article 226 before the High Court. So right to move Supreme Court can be exercised only through appropriate proceedings. Appropriate proceedings. This expression has reference to proceedings which may be appropriate having regard to the nature of the order, direction or writ which the petitioner seeks to obtain from the court. Sometimes, dear students, even a letter written to the Honorable Chief Justice of India or a telegram sent to the Chief Justice of any of the High Court or Supreme Court, although nowadays telegrams have been banned, or even a postcard addressed to the Supreme Court may be regarded as appropriate proceedings. Under its epistolary jurisdiction, the Supreme Court in its premises has opened a public interest cell where all the letters written to Supreme Court are scrutinized and cognizance taken on the basis of newspaper clippings are also included in the epistolary jurisdiction of the Supreme Court. So, dear students, the right conferred by Article 32, which itself is a fundamental right, cannot be abrogated, abridged away, or taken away by an act of parliament. You cannot reduce the power of the Supreme Court. Here is an illustration, Premchand Garg versus Excise Commissioner of UP. Supreme Court struck down one of its own rule. You see, Supreme Court has framed rules for the conduct of business. Likewise, every High Court has its own rules for the conduct of business. So one of the rules framed by the Supreme Court itself says that petitioner has to furnish security as a condition precedent to the hearing of petition. Supreme Court struck down this rule of filing a security as a condition precedent to the hearing of petition because it imposed a final obligation on the petitioner. And if the petitioner is poor, he is not in a position to comply with this furnishing of security, then his petition would fail. And his right to move Supreme Court under Article 32 will be defeated. So Supreme Court struck down its own rule because that rule requires that petitioner will have to furnish security as a condition precedent to the hearing of petition. And if a person is poor, he cannot file security, then he cannot move to the High Court. His fundamental right under Article 32 will be a waste paper. So Supreme Court said that no, you cannot obstruct the right of a person to reach the Supreme Court. Then, dear students, as I told you in the beginning, that the words used in 32 as well as 226 are in the nature of the power to issue writs in the nature of habeas corpus, mandamus. These words specified in Article 32, Clause 2. This means that writ may not be exactly in the nature of 5 writs. It may be even beyond the concept of 5 writs because orders can be issued in the nature of 5 writs. Therefore, if the conditions for issue of any of the 5 writs are not fulfilled, Supreme Court may still issue writ in appropriate cases. And in exercise of such wide powers, Supreme Court directed the state government to pay compensation in Rudul Shah versus State of Bihar. What happened in this case? Rudul Shah was charged with a criminal offense, but he was acquitted by the competent court of law. Unfortunately, he was in jail. He could not get bail during pendency of the suit, pendency of the criminal case. And he was acquitted. On acquittal, release order was sent to the jailer so that he may release the he may release the accused Rudul Shah immediately. But see the bad luck of Rudul Shah, that he was detained in jail for long 14 years, even after his acquittal. And probably this can happen in Bihar only. So a writ was filed in the Supreme Court. And Supreme Court directed that state government will pay compensation to the Rudul Shah for his illegal detention for the long 14 years. So see, the writ was only habeas corpus for release of Rudul Shah. What about grant of compensation? How compensation was part of habeas corpus? It was that the Supreme Court can pass orders in the nature of habeas corpus also. So nature of habeas corpus enlarges the scope of habeas corpus, whereby the courts are empowered not only to release the illegally detained person, but to order for payment of compensation also. So these words in the nature of habeas corpus are important. Then we have another very important illustration on this point, Vishakha versus State of Rajasthan, where Supreme Court issued detailed guidelines for protection of the women against sexual harassment at workplaces, exercising its writ jurisdiction of mandamus. Guidelines were issued. So they were in the nature of mandamus. Guidelines were in the nature of mandamus. And later on, these guidelines were incorporated in the shape of an act by the parliament. And dear students, this distinction is now clear to you, that Article 32 is applicable only for the enforcement of fundamental rights. And the jurisdiction vested in Supreme Court is exercisable only for enforcement of fundamental rights conferred by Part 3rd of Constitution of India. Article 32 will have no application if fundamental right is not violated. Then dear students, few fundamental rights are available against private citizens also, private individuals also. So when a fundamental right is also available against private individual, then writ can be filed against private individuals also. Like fundamental right of abolition of untouchability, Article 17, and still somebody says to a scheduled caste person that you are untouchable, please don't come to my residence. This is an offense. And scheduled caste has a right of filing a writ petition against me as a private person also. Likewise, Article 23, prohibition of traffic in human beings and forced labor. So who will employ human beings in traffic? Who will employ labor forcefully in the factory? It is again the private person. And likewise, Article 24, prohibition of employment of children in factories. Who will violate it? State is not going to violate it. Only private persons are going to violate it. So in such circumstances, the writ can be filed against private persons also. And Supreme Court can always be approached for appropriate remedy against violation of such rights, even by private individuals. And this was held in People's Union for Democratic Rights versus Union of India, decided by the Supreme Court. So dear students, we have seen that high courts have power to issue 5 writs. On the other hand, Supreme Court also has the power of issuing the same 5 writs. So whether one should go to the High Court first and then approach the Supreme Court, what should be done? See, legally speaking, the jurisdiction of the High Court and Supreme Court is concurrent. Both the Supreme Court and all the High Courts in the country, they do possess concurrent powers to issue orders and writs in the matters of enforcement of fundamental rights. And it is no condition for exercise of jurisdiction by the Supreme Court that the petitioner must, in the first instance, approach the High Court. It is not required. But in view of enormous pendency before the Supreme Court discourages petitions under Article 32 if equally efficacious remedy can be availed of in the High Court. Then they direct the petitioner to approach the High Court first. Then, dear students, this is also important to understand that once a petition under Article 32 has been decided, it is subject to principle of res judicata. Res judicata means things decided by the court shall not be heard again. So petitions under Article 32 are subject to rule of res judicata. Therefore, if a petition has been decided by the Supreme Court under Article 32 between the same parties, so the same question cannot be reopened between the same parties under this article again and again. And similarly, if a petition has been decided by the High Court under Article 226, same petition will be barred by the principle of res judicata, and a fresh petition in Supreme Court will not lie. This is very important. You must remember it. We have an important leading case on this point. Two important cases. One is the Rey Housing versus State of UP. In this case, the respondents objected against the maintainability of 6 writ petitions under Article 32 on the ground that each one of the petitioners had already moved High Court for similar writs on the same facts, and the High Court had rejected them. Now the rule of res judicata will apply. Supreme Court held in this case that writs were barred by the rule of res judicata and could not be entertained. Why? Because the High Court has already decided a batch of 6 writ petitions, and on the same cause of action, same facts, you are re-agitating before the Supreme Court. So second set of writ petitions is barred by principle of res judicata. You cannot approach Supreme Court again. Similar is the case Gulab Chand Chotelal Parikh versus State of Gujarat. In this case, what happened? That Gulab Chand Chotelal filed a writ petition under Article 226 in Gujarat High Court. And High Court said, no, you are liable as a surety. Since you stood surety to certain loan transactions, you cannot escape your liability as a surety. So his writ petition was dismissed. Now he filed a fresh suit in the lower court that he is not liable as a surety. Matter reached up to Supreme Court. Supreme Court said that your suit is barred by principle of res judicata because once it has been decided in the writ jurisdiction that you are liable as a surety, we will not rehear the same thing once again on a regular side also. He must have thought that lower court may not be aware that I have filed a writ in the High Court first. But you cannot hide it. The other party will bring the facts to the notice of the court that Mr. Gulab Chand was held liable as a surety. His writ was dismissed by the High Court. So, second set of proceedings in the shape of a fresh suit are not maintainable. They are barred by principle of res judicata. Then we have one exception to the rule of res judicata, that is writ of habeas corpus. Suppose your writ of habeas corpus has been rejected by the High Court, you can go to the Supreme Court with a second petition also. This is exception. The writ of habeas corpus is a great exception to the rule of res judicata. If a writ of habeas corpus has been refused by the High Court, then the petitioner can file a fresh petition before Supreme Court under Article 32. Even repeated petitions can be filed before Supreme Court under Article 32. And even the rule of constructive res judicata is not applicable to habeas corpus. If a SLP under Article 136 is dismissed against order refusing writ by the High Court, a fresh petition under Article 32 can be filed only if circumstances have changed. You have a new grounds, new circumstances. And the grounds which were not available when earlier petition was decided, now those grounds have become available, then you can file a fresh petition even after dismissal of your SLP. You can go for exercising writ jurisdiction provided the circumstances have changed and grounds which now you are pleading were not available to you when 136 SLP was decided by the Supreme Court. Then, dear students, time and again the respondents used to plead that the petitioner has an alternative remedy. So court should not issue writs. Truly speaking, existence of alternative remedy is no bar to the grant of remedy under Article 32 and 226. The Supreme Court ordinarily insists that alternative remedy should be availed of unless the alternative remedy is of no use to the petitioner. Truly speaking, extraordinary remedies like Article 32 and 226 should not take the place of ordinary remedies. They are special remedies. Even if some alternative remedy is available, it is no bar for filing a writ either in the Supreme Court or in the High Court. Can you use this Article 32 and 226 against the courts? Answer is no. An order passed by any court cannot be attacked under Article 32 on the ground that order violated fundamental right of a citizen. Judicial orders by themselves do not violate fundamental rights. Courts are there to impart justice between the parties. Courts are not meant for violating fundamental rights. And as you know, the courts are outside the definition of state as defined in Article 12. So these writ jurisdiction cannot be availed of for challenging the order of a court on the ground that order is violating the fundamental right. Then comes Article 32, Clause 4, that right to move Supreme Court for enforcement of fundamental rights shall not be suspended except as otherwise provided in the Constitution of India under Article 359, which empowers the President of India to suspend the fundamental rights when proclamation of emergency under Article 352 is in operation. It is the only circumstance when Article 32 can be suspended. But not otherwise. This is your fundamental right. We have illustrations where these fundamental rights under Article 32 were suspended. In 1962 and 1971, emergency was proclaimed on the ground of external aggression. Then in 1975, emergency was proclaimed on the ground of internal disturbances. On all the three occasions, the enforcement of some of the fundamental rights was suspended under Article 359. But there is an amendment in our Constitution done by 44th Constitutional Amendment, which says that suspension of enforcement of fundamental right under Article 20 and 21 cannot be done, even if emergency is there. The fundamental rights granted to accused persons under Article 20 and fundamental right granted to all persons, all citizens under Article 21, that is fundamental right to life and liberty, cannot be suspended even during emergency. So dear students, now we have a summary of writ jurisdiction and their meaning before you. That is habeas corpus, a Latin word which means you may have the body or the person. This is a writ for protection against illegal detention. Then second writ is mandamus, which means we command. We command positively as well as negatively. We can compel you to do certain things positively or not to do certain things negatively. Prohibition means we prohibit. Quo warranto means show your authority. If you are holding the post, your appointment as Civil Judge Junior Division can be challenged under this writ of quo warranto. Suppose you have qualified for Civil Judge Junior Division, but your LLB is not complete. Your appointment can be challenged under writ of quo warranto. Certiorari, where we quash the orders of the lower court. Then we have curative writs also, which means that we cure the defects in our own orders. And then finally, we can review our orders also. So dear students, this is all about 5 categories of writs. So thank you very much. God bless you all.